This is From the Bar, an inside look at compliance with Roger Fendelman, brought to you by Interthinks, a smarter approach to risk. Now, here's Roger Fendelman.
Confusion abounds in the lead up to 2014. If you don't believe me, just knock on your compliance officer's door and ask, "Is everything okay?" There are many unresolved issues surrounding several of the new rules scheduled to take effect in January. At the top of the list are multiple LO comp issues and nuances in the qualified mortgage rule. The MBA, led by their veteran regulatory counsel, continue to ask pointed questions to CFPB leaders to help further define various originator scenarios in the context of the new rules. For example, what happens under the new LO comp rule when an angry borrower asks to speak to the office manager, an all too common occurrence, and the manager, a non-licensed non-producer, agrees to modify loan terms, give a credit, or even give a rate lock extension. In doing so, she has likely committed a violation. So, what to do in a situation like this? Well, one solution that's been suggested is that she disguise her voice and pretend she's someone else. Although I suppose that might also be a violation in its own right. All joking aside, confusion abounds too when discussing the issue of whether different payouts to LOs could be had on purchase versus refi transactions. Industry leaders are seeking clarification of these and many other compensation issues, but are facing a seemingly uphill battle. The QM rule also has its own twists, turns, and conundrums. For example, exactly what is the standard industry practice for interest rate reductions paid for by discount points? Is it 0.25%, 0.125%, or something altogether different? This is an important question because the QM rule requires the standard to be met in order to potentially exclude the points from the 3% fees calculation as bona fide. A senior regulatory attorney from the CFPB recently intimated that both percentages may in fact represent standard industry practice, but that in the end, time will tell. This isn't something to be taken lightly. With the new ultra-low 3% fee cap, most lenders are going to need to be able to find as many ways as possible to exclude fees from it. Another twist in QM is regarding fees paid to affiliates. It's now painfully clear that virtually any fee paid to an affiliate or fees paid into escrow of an affiliated settlement agent must be counted in a 3% fees calculation. What precisely is an affiliate for purposes of the QM rule? Check the Bank Holding Act definition, not the RESPA one, which, if memory serves, defines an affiliate in part as where the originator holds more than 25% interest in the company. Here's an interesting outcome. When it comes to fees paid to affiliates, the QM rule makes no distinction between owners and lenders' title insurance. This means that even an owner's title insurance policy paid to an affiliate must be included in the calculation. On September 30, HUD announced its proposed version of the QM rule for FHA loans. With it comes a unique twist on the higher-priced rate portion of the QM test. The spread is now the applicable APOR plus the aggregate of the upfront MIP percentage and 1.15%. This was done apparently with the idea that HUD wanted APOR plus 2.5 and recognized that the MIP percentage costs consumers on average 135 basis points. It's widely hoped that HUD adopts the simpler APOR plus 2.5 calculation in its final rule. But that's not all. It appears that there may be no rebuttable presumption QM for FHA loans. This is because a lender is still required to calculate residual income, which essentially puts it in ability to repay land at this point. Now, here comes the ultimate QM conundrum. For even good faith violations of the rule, there is no cure. Thus, if you accidentally have 3.01% in fees, you may well have a non-QM loan. CFPB counsel states the belief that this may still meet the QM definition. Industry lawyers, however, see it another way. The policy of the GSEs is to not purchase non-QM loans. A GSE policy leader recently stated, however, that they would be willing to purchase loans with technical errors such as these for the first months of 2014, unless, of course, a borrower proceeds with a legal challenge. Is your head spinning yet? Well, stay tuned, as there's much more to come.
That was Interthinks expert Roger Fendelman. Tune in again next month for another podcast from the bar.